without further ado, on to the first question. And this one's for you, Christo. Christo, our paper outlines some potential harms of algorithms directly to consumers, i.e. not through competition. Which of these do you think are the most concerning and why?
Well, thanks for having me, everyone. So in terms of what I think is perhaps the most disturbing, the portions of the report that talk about issues related to personalization and choice architectures and sort of dark patterns and interfaces, those are the issues that are currently most concerning to me. So, my research focuses on algorithm auditing. I spend a lot of time looking at online platforms and trying to figure out what data they're collecting, how that data is used to change the interface, and ultimately the impact this has on people. In our work, we haven't seen a lot of examples of price discrimination or price personalization. It happens, but my perception is that there's less pressure on companies not to adopt these, as opposed to things like personalized pricing. So I've had conversations with a number of firms where they asked me things like, do you know of other firms that do personalized pricing? Is there a way to try and do this fairly? And they were thinking about implementing these practices, but they hadn't done so yet. And the reason largely was because they were concerned that people would notice and people would be really angry and disturbed by this. I don't necessarily think that criticism applies to these other forms of personalization and kind of nudging. It seems like there's a little bit more of I wouldn't say a consumer acceptance, but less of a rejection of these techniques because they're so widespread. So again, there's just more of this happening, and it seems like you can get away with it more. The final point I'll make is that I think that these interface issues and things like personalized ranking are really concerning because they are potentially more challenging to regulate. If we look at, for example, consumer protection law and jurisprudence in the US and in Europe, things like competition and pricing, they're fairly well regulated. You're not allowed to do price discrimination in many respects. But these other issues like, well, is it okay to have a personalized ranking or to nudge people towards a particular product? That's a lot more challenging to regulate, in my opinion. Is it deceptive? Maybe, maybe not. If it's not deceptive, how do you quantify the harm in a precise way such that you can build a case to try and influence this behavior or stop it? So I'm not suggesting that these things shouldn't be regulated. I absolutely think that they should. I'm just saying that it's the jury is sort of out on how to do this in a way that's effective. And until we reach that point, firms are going to continue to experiment and push the envelope in these regards with these choice architectures and nudging, potentially to people's detriment, which is really concerning to me.
Lovely. Thank you very much, Christo. Do any of the other panel members have anything to add?
Yes. Hi, Stefan. Maybe to add two comments from my end, very much in line with what Christo mentioned. But first, maybe regarding the market mechanism, and I think it's important just to highlight the way in which the ability to affect our perception as to the options really affect our understanding of the competitive market and the competitive landscape. And of course, this is not unlimited power because there is a reputation course, and Christo alluded to this. And this is why we have framing that is often very crucial here. But the result is that as customers, we have a distorted image of our options on the markets. And in such an environment, it's very hard for us as consumers to optimize our decision making. And the second to that is maybe to link this to the platform reality. And I think here it is important to stress that this is not only an issue of market power, where you have a gatekeeper or a website that is using all these cues in order to manipulate us as users. Once you move that into a platform environment, what you have are architects. You have companies that control the totality of the ecosystem, and they are the game makers. So they don't just benefit from simple market power, they actually design all the parameters of competition. And this truly amplifies some of the elements that Christo referred to. So you have an illusion of control as a customer, but in reality, you have an environment that is not subjected to organic competition. Everything is controlled, demand is controlled, supply is controlled, and basically you're on a movie set. To leave you with an image, you might have the illusion that you are in a very busy market in a very large city, but you're basically on a tour in Universal Studios.
That's great. Very evocative, Ariel. Thank you very much. So actually, I'm going to stick with you, Ariel, and I'm going to ask a related question, but in the competition space, moving into the competition area. Which of the harms regarding exclusionary practices or algorithmic collusion do you think are most concerning, and why?
Thank you. So there are obviously quite a lot of technological developments, and it is a moving target. But if I had to choose two, I would probably pick one from the pricing area and one from the exclusionary area. And in pricing, we had some good examples of collusion, resale price maintenance. But what I think we need to focus on a bit more is the area of hub and spoke. And this is the idea of hub and spoke, which is facilitated by algorithms. And the most obvious example is that of smaller companies that would like to engage in dynamic pricing or would like to engage in personalized pricing, but do not have the analytical capacity to do so. So they outsource that function to a provider. And that provider, of course, then runs and manages their stock and their pricing. And it does so by engaging in the function of all the time looking at demand and supply curves and optimizing the price. And the interesting question and the interesting trends that we start to see is that you have a handful of those companies. And the question is, what then happens if the same companies or the companies from the same industry, the same market, use the same provider for their pricing decisions? What you may have is an incidental hub and spoke. So this is not your typical cartel that I intentionally joined and communicated with others, but there is a very challenging question here. In theory, the algorithm should look at the market, subject to all the uncertainty on the market to determine and optimize your pricing. But if all the market or a big part of the market sits already on the server, then the algorithm is not subjected to that uncertainty. In fact, more and more of the players are serviced by the same algorithm. And something that should give us a pause and we should probably worry about is the fact that some of those providers actually promise the users that they will not only provide them with dynamic personalized pricing, but they will also guarantee that the likelihood of price wars will be reduced. So it really gives us a hint as to how increased transparency and increased concentration in pricing can dampen competitive pricing. And the other, if we move to exclusionary pricing, I think there's no doubt that the environment, which is increasingly vertically integrated platform environment, is the one that should be at the center of debate. We had a lot of discussion already, policy discussion. We have cases that deal with self-favoritism, and no doubt that as we are all using fewer gates to the internet, as we all voluntarily outsource a lot of our decision making, either to automated systems, to digital helpers, this becomes an area where self-preferencing is quite crucial. Now, we've heard already about the Google story, and we're familiar, of course, with ongoing investigations. And in those areas, we sometimes have a relatively clear idea on how the self-preferencing works. You have a buy box, you have a comparative box, you have different application of search terms that is different from another service that is excluded from, let's say, the organic search algorithm. But what we have to understand is that in an algorithmic environment, we are increasingly moving, very much in line with what Christo mentioned, to an ability to engage in exclusionary conduct using much more subtle cues. So you can create friction that is not as obvious. It is not as obvious as having someone that is completely separated and is just plugged in front of you. You can manipulate screen design. You can manipulate prompts. We're all familiar with the use of defaults, but you can more widely deal with imperfect willpower, complexity, choice overload. And all these elements can lead to exclusion without it being one of those easier, and there's nothing easy about those cases, but let's say relatively easier cases where it was more obvious that we see exclusion. And I would even argue that in some platforms where you want to give the perception of a marketplace, there is a very delicate balance. You want to give choice, but you want to make sure that customers do not exercise that choice. And this is another area that I think will attract a lot of attention. And if I left you earlier with one image of Universal Studios, I'll stay with the film industry and leave you with another. So if you think about the Truman Show, in the movie Truman Show, Truman, of course, had the illusion of control. But one thing that is interesting, there was a bridge that led out of the island. And there wasn't a gate on that bridge. No one blocked the bridge. And presumably on the other side of the bridge, you had all the options that Truman could exercise, and yet he never used the bridge. And he never used the bridge because ongoingly, the game maker made sure to have sufficient cues, sufficient behavioral manipulations to prevent Truman from exercising his choice. So at the end, Truman served the game maker rather than the other way around. And again, I think that image maybe explained the idea of exclusion without a visible gate on the bridge. Thank you.
Thank you very much, Ariel. Again, another very evocative image. I really think the Truman Show is not going to leave my mind now. That's a brilliant meme. So I'm gonna. We're actually doing great on time, by the way. So I'm going to open out on this question. But actually, if anyone else wants to follow up on this one, or even come back to the consumer question, please do. So if any of the other panel members have got anything to add in terms of competition, I'm going to go first to Bill Kovacic.
And again, Stefan and Kate, thanks so much for the opportunity to participate in the conversation, and to Christo and Ariel to getting the panel discussion off to such a great start. I think Ariel underscores a couple of areas that are decidedly important in thinking about what competition agencies should do over time. On the collusion point, I think what we've seen with absolute clarity in over 130 years of experience with competition laws is that potential or actual participants in collusive schemes are very adaptable. And they respond with enormous ingenuity and speed to enhancements in the enforcement process that seeks to detect illicit arrangements and to punish them. We've had major improvements in techniques for detection and for sanctioning in the competition world over the past 30 years, notably the development of leniency mechanisms to identify misconduct and the steady ratcheting up of punishments. But none of us should be comforted by a sense that in some ways this has achieved optimal deterrence. And Ariel has underscored in extremely ingenious and effective ways that firms can achieve coordination that are harder to detect, more difficult to understand, but perhaps quite effective. One thing we've seen from other collusive schemes is the importance of intermediaries of the kind he describes. That is, firms that consciously or less consciously can facilitate coordination. And the firms in the tech sector that can do this kind of algorithmic coordination, I think, become ever more important as focal points for attention. So I think one thing that Ariel has very properly identified is the extent to which we are certain to see adaptation and adjustment on the part of firms that would like to coordinate behavior and would like to operate in the shadow of existing legal doctrines and enforcement techniques, and that this is worthy of increased attention by agencies over time. And just a word about exclusionary conduct as another dimension of the problem. There are some encouraging developments lately that suggest that we'll be in a position to understand a number of the relevant practices better. A useful byproduct of the trials that had been the cases that have been launched in the United States, a total of 5, 3 of them involving Google, is that antitrust trials tend to be wonderful opportunities to peel back the curtain and understand exactly what takes place inside the enterprises. So I expect that we're going to learn a lot more about the phenomena that Ariel was describing. The difficulty is that we're going to learn very slowly. The principal case brought by the Department of Justice is now scheduled to begin the trial in September of 2023, which means that a decision in the case would probably not take place in the first instance until early in 2024, with a tour through the appellate process lasting at least until the middle of 2025, and then a trip to the Supreme Court, 2026. That's over 5 years away from now. And the industry, I suspect, will change just a little bit in that time, so that there are steps in motion to give us better insights about these phenomena and their competitive significance. There's the painful awareness now that those are going to move at a terribly slow rate, so that the world races by like a Formula One racer, and we're riding a bicycle trying to catch up through our traditional tools. It makes one wonder whether or not the traditional mechanisms of litigation really are fit for purpose. And it focuses attention on the efforts to develop new regulatory tools and investigative tools to understand what's taking place in a more timely manner.
Brilliant. Thank you very much, Bill. That was a very helpful perspective and a very sobering perspective when we look at the potential timelines of the US actions. So Kathy's signaled that she's got quite a few things to add. So I'm really looking forward to what Kathy has to say. Over to you, Kathy.
Hi, thank you. I just, and this is probably not the technical definition of collusion that I'm going to just make one point about, but I just wanted to make the obvious point that, like, you don't actually need it to be intentional collusion. Like the incentives themselves often proffer the opportunity to many companies to do essentially the same thing, and this essentially create the same harms with algorithms without any facilitated collusion. One example, of course, but my larger point is that, like, it's really important, and I'm about to speak, I believe. I think I'm the next person to speak on should regulation look. And I'm really glad we can talk about that, because it's really important to me because of these sort of common incentives and common data problems, if you will, or data effects, that we can't just concentrate on collusion, or for that matter, monopoly, because it will happen even if you break things up, even if there is no collusion. These kinds of things will sort of happen in concert, simply because of the combination of the incentives and the data. That was just my small point. Thank you.
Thank you very much, Kathy. And you've done a brilliant segue to yourself there. For the audience, how do you think algorithmic systems should be regulated to mitigate some of the potential harms that we've discussed, but without stifling innovation? And in your view, what's the role of algorithmic auditing?
Yeah, so, well, thank you for having me. Thank you for letting me introduce myself. So I just want to start by saying I'm really glad we're having this conversation. I think this is a long conversation, and I think we should think about it as incrementally improving these kinds of, first understanding and then trying to mitigating algorithmic harms over time. And I also like the point earlier that was made earlier, I don't remember by whom, that algorithms can individually be harmful, but they can also act in concert to harm. And it might not even be intentional. If you think of like flash crashes, I think the example given earlier was like these algorithms, once they go at it, they somehow increase prices for consumers. They might decrease prices for consumers in concert, but the point is that like we should keep an eye on not only individual algorithms, but how they create their own dynamical systems, and because that could be problematic as well. So with that introduction, I don't focus on platforms. So some of this will and some of this won't be as applicable to platform situations like Amazon marketplaces, but I do want to give a little bit of perspective from my experience of auditing. In particular, I've done a lot of sort of adversarial auditing when I work with the Attorney General's offices to understand and enforce laws in terms of predatory lending. And my experience has been like we spend months and months, and I say adversarial because it's like we subpoena the data. So we don't assume that they explain their algorithms very well to us, but we can see what actually happened based on the data that we get. And what we do over time, over many months, is we like basically put together evidence in a case for a judge that this, we quantify exactly what happened and we say this was illegal. In other words, we have a quantified rule that was broken. And often the judge says that, yeah, that's pretty convincing, and like this to pay rest, and then it seems like that rule just gets thrown away until the next time we have a sort of unfair lending case or something along the lines of discrimination in lending or something like any kind of law that they claim has been broken. We have to sort of build up the evidence from scratch. And so my high level suggestion is don't disappear those learnings. Like take those reactive quantified rules that were broken and say, well, this is now a rule. And instead of just recreating it every time, we're going to proactively monitor the companies that are using algorithms like this in contexts like this, and say, you have to monitor your system to make sure that you're not breaking this rule. So in other words, if it's like a lender, like, is your effective APR 500%? So it's like we have to define what it means to be effective APR. And it has to be applied in the right context. But the idea is like, well, why not, since we've gone to the trouble of making this rule, make sure that everyone who might be breaking this rule and would be in trouble if they did actually keeps an eye on whether they're breaking this rule or not. But inherently in that piece of advice, I assume that there are like groups of algorithms working similarly to each other in similar contexts. So for consumer lending, that's actually a pretty reasonable assumption, but maybe a little bit weirder and more idiosyncratic situations, like, again, like platform marketplaces. Like there are just not that many, since it's monopolistic, there aren't that many different companies that can be contained by the same rules. Even so, if even so, I'd say that we want to basically find rulings that went against companies and make sure that from now on they are monitored with respect to that. Second point I want to make is that this is a black box algorithm monitor. Like we do not want to know ever how they think about things, what rules, how their algorithms work. We don't really care. I think it's a mistake for regulators to start asking about explanations or any kind of deep thoughts of algorithms. I just think about simply like who goes in and what comes out, what goes in, what comes out. One other idea would be, and this is something that I think was in the paper, this idea of a regulatory sandbox of like having piles of data that companies could be allowed to look to see whether their algorithms were following rules, whatever rules are defined as so far. I think that's a great idea, but I do want to caution that like no matter how like good a data set you have in a sandbox, if I understood the concept correctly, the sort of feature of big data that people like so much, this context, is that there's like weird data that people use. Like, like maybe one credit company might ask applicants, like what brand of ketchup do you like, and they think that they can figure out something about risk based on ketchup. There's very little chance that a regulatory sandbox data set would also have, in addition to salary and FICO score and age, would have the information of a brand of ketchup. And what that means is you could only test so far in a given sort of gold standard data set, but you'd be missing that final proxy. I think there's probably a lot to be said for regulatory sandbox approaches, but I'll just finish by saying that until we restrict companies to use only these data, which is very unlikely. I think companies really like using idiosyncratic data. We're going to have to do a combination of methods where we ask them to show us how their algorithms work on, in this narrow context, but we're also going to have to do some kind of in the wild black box audit where you're like, show us what actually happened with your algorithm. So, so we're not seeing some kind of VW type thing where you have a good looking model when you get it tested in this very narrow context, but then it actually behaves quite badly in the real world. So it has to be some kind of amalgam of methods and approaches when you're talking about how to regulate algorithms. Thanks.
Thank you very much, Kathy. That's just a really, really useful real-world perspective of how to think about these things. So before going out to the next panelist, I've got two things to say. So one is we're doing well on time, which means we would love to hear from some of your questions. So please do get out to the live chat on the right of the stream and send us some questions. And the second one is Gordon and Helena, as those questions start to come in, hopefully, can you start kind of putting them together and sending them to me and the panelists. So without further ado, I'm going to staying on the questions of regulating algorithms without stifling innovation, and also thinking about algorithmic auditing. Over to Christo.
Thanks, Stefan. So just building on what Kathy was talking about, when we talk about regulating algorithms, I think the reaction is immediately jump to like ex ante regulation. So regulating specific kinds of algorithmic behavior or mitigating against specific harms. And those are obviously super important. But I also don't want to foreclose the possibility of other kinds of regulation around transparency itself. You could imagine, forcing firms just to reveal when algorithms are at play or when A/B testing is being conducted. Even that just basic level of information is not often available. So the last thing I'll mention is that, when we're talking about auditing is a fraught process for people like me because it may or may not be legal. Just for example, looking at the US legal doctrine, the laws around things like collecting data from websites are very unclear. So if we agree that there should be scrutiny of platforms and systems, we need to make the environment amenable to people like myself, academics or investigative journalists or people like Kathy, so we can do our work and actually not fear being held criminally liable for doing work that's in the public interest.
Thank you, Christo. I know a few people from government, including ourselves, are on the call, so I certainly heard you loud and clear. I'm hoping some others did as well. But I would like to come back to you on one thing to clarify before moving to the next question, is when you say mandated third-party audits, do you think that, when do you think that should come in? Because for large firms, sure, I think those who are partial to your view will agree. But what about small firms, for example?
Yeah, this is a very challenging question. If you mandate third-party presence from the moment of product conception, that's great because you'll have kind of this inside line when it's very nascent. You can impact kind of how it unfolds. But I'm also cognizant of the fact that this is a huge burden you're asking a small firm, a new market entrant to bear. So I think there has to be some sense of proportionality here. maybe we're just talking about the biggest firms, or maybe we're just talking about specific product verticals. Alternatively, there's nice work being done on how companies can do internal audits with adversarial teams, kind of like how there's internal, cybersecurity and red teaming. You could easily, more easily mandate something like that, with some requirement that that process eventually produce something that's open, right? That you engaged in this process, and this is the documentation it produced. And then later, that helps facilitate truly independent third-party auditing as well.
I think it would be a good idea for the Public Regulatory Authority to have its own organic capacity to do some of the auditing on its own. We've had experience in a number of public policy areas where agencies have essentially outsourced all of the compliance and monitoring to third parties, sometimes called monitor trustees and others, to oversee the implementation of specific regulatory obligations. That's been a mixed experience. And I think if an agency doesn't retain some of the capacity to do it itself, I think it loses touch with some of the implementation issues that are realistically faced day in and day out. I think it's missing an opportunity to learn in more detail about how some of the regulated firm systems operated. So my suggestion is, in thinking about the mix of auditing, I would like to see the agency have some internal capacity to carry out these oversight functions on its own, if only to understand better what the third-party monitors are doing, but also to be in a better position to oversee the functioning of the compliance program as a whole.
So, Bill, you've got lots of experience in how competition authorities can tackle difficult issues. What could we do collectively, that's in the UK, working with other agencies internationally, to move forward and build the kind of analytical capability that we're talking about?
I think that all of the presentations so far have underscored a tremendous challenge to capability on the part of the regulatory authorities. And that is, how do you acquire and sustain the level of knowledge to do an accurate diagnosis of the problem, to identify promising cures, and then to implement solutions in an effective way? That's not an easy thing to do in any area of public policy making. It is the hardest problem when you're facing an extremely dynamic sector that is technologically complex, and the dynamism involves daily changes to the business environment, both with respect to the technology and the business model that's evolving in rapid form. In order to do good work in this area, the regulator has to be proficient in the technology, to understand the developments. If it's going to do a good job, it has to know what it's looking at in order to formulate a program for intervention. So how do you avoid malpractice in the regulatory arena? One is that you grow the internal capability to do this work. And it's why I am so excited by and encouraged by the steps that the CMA have taken to build the data unit. And notice the size of the commitment. It's a team of 40 now. So what are you doing to put yourself in the position to be knowledgeable? I think the creation of the data unit at the CMA is an enormously promising step. And it is, by the way, from what I've seen around the world, it is plainly state of the art. There's not another competition authority in the world made this kind of commitment to building the knowledge necessary to do good work in the area. So that's step one. My prediction would be that if we look ahead 5 years, there won't be a significant competition authority in the world that's doing work in this environment and seeking to carry out an ambitious program that will not have some variant of the CMA data team. That is, this will be emulated and adopted in other jurisdictions, because to do good work, they'll have to. So those are things you can do inside. But success also depends, and I think I'm echoing comments of my colleagues as well, on the extent to which you draw upon capabilities that exist outside the institution. One is the regular convening of events that involve asking experts on the outside to share what they know with the agency. This has to be an ongoing conversation. So the role of the agency as a convener in routinely seeking the views of technologists, business people, citizens, advocates, academics, and other groups, I think is a vital way by which the agency absorbs information that's crucial to its ability to do its work well. A second way in which it reaches out is that it uses the instruments at its disposal, compulsory process and other information gathering tools to do research that puts it in a position to understand, again, what's taking place. And I think it forms partnerships with other institutions, with intellectual hubs, academic hubs, engineering departments, computer science departments, technology departments. It works with academic hubs that have deep understanding and knowledge in these areas and shares what it knows with the institutions. And it builds relationships, last point, with other competition authorities around the world. It's a glib observation to say that public agencies at home and abroad should cooperate more. It's a truism. Making it work in practice is very difficult, so that you have not just the occasional discussion, but a genuine collaboration that takes the form of developing a common research agenda, routinely sharing the knowledge that's been assembled through individual initiative. I think if authorities do not engage in this collaborative effort, they will not be able to get their arms around the problems that they face individually. Individual effort will be inherently inadequate to address the problems, which is why, again, promising efforts underway, the CMA is involved in several of these, to work with similarly situated institutions in other countries, in the United States, in Australia, Canada, New Zealand, to work with them in developing cooperative programs, both with respect to understanding the phenomena, but developing implementation methods including monitoring, oversight, compliance, that puts you in a position to carry out a program more effectively. Kathy was referring to what lawyers would call rulemaking as an alternative to case-by-case adjudication, distilling the knowledge acquired from study and cases into prescriptive rules. This is an area where the conscious effort by different institutions to pool their learning and knowledge to develop common solutions, I think, offers not just a promising path for improved policymaking, but indispensable if they're going to do this kind of work effectively. So, addressing the knowledge problem through internal efforts, acquiring the right people, building the right internal organization framework, and then the relationship with outsiders, with Alan Fels, the former chair of Australia's Competition and Consumer Agency, called co-producers, groups on the outside who, as partners, affiliates, can develop common programs to build effective regulatory responses, and taking account of the broad experimentation that's already emerging to develop methods to experiment, to identify promising techniques, and then opt into them over time, I think becomes ever more important. But I'm enormously encouraged and excited by the steps that the CMA are already taking to do this.
That's great, Bill. Thank you very much. A wonderfully rich perspective. So, Kathy, we're going to head over to you. And I'm really interested to hear what you think regulators should be doing internationally. And then we'll be going to audience questions. Kathy.
Yeah, thanks. I'm really glad to hear what Bill said. I agree with him. And I want to emphasize how important it is for regulators to be competent in this world. We cannot depend on third-party auditors. As I say that as a third-party auditor. And the reason is I just don't want, I should mention that I worked in finance before I became a data scientist. And I saw the corruption of Moody's, S&P, and Fitch, and the credit rating agencies, firsthand. They were just liars, and it was a corrupt industry, and probably still is. We can't let that happen to algorithmic auditing. It's just far too important. And And part of it is that we need to have transparency on methodology and transparency on results. And as a third-party auditor, I can't do that. I can't require that. Why can't I require that my audit becomes, my methodology and the results become public? Because there is no, essentially there's no regulator breathing down their necks. So in other words, like even when I'm trying to audit for compliance with existing law, it's like the power is in the hands of the companies with the algorithms. So I just want to emphasize how important it is that the regulators get on the ball and have expertise so that they don't get snowplowed by like the lobbyists in these various industries to make bad rules or rules that are easily bypassed, and that we can't, and to be clear, we cannot depend on third-party auditors to save the day, because the truth is, if we don't have standards in third-party auditing, which we can only require as third-party auditors if like we have regulators behind us, then third-party auditing is just going to go the way of just selling stamps of approval, which is not what we want to see. I'll stop there.
Lovely, thank you, Kathy. Ariel, I know you've got some thoughts on the internationalization of the regulatory practice, but I'm also keen to make sure we get to the audience questions. So if you could answer that, and I'm going to throw a second one for you as well. And that's, I've seen that John Crowcroft has asked about the idea that we might see emergent phenomena, in particular implicit collusion might be an emergent phenomena. So first of all, how do we internationalize? And secondly, how do we deal with implicit emergent collusion?
Yes, thank you, Stefan. So first, just in terms of enforcement, I think it's important for all of us to appreciate, and it came through all the discussion, that markets simply do not correct themselves in the environment that we are discussing. So the current market concentration, the current dynamic is such that algorithms are not used necessarily in ways that promote our interests as consumers. Sometimes they do, but sometimes they don't. And this just highlights that there is truly a need for greater intervention. And of course, we need to be mindful of government error and on the need for really optimizing the level of intervention. But the key point here is that we cannot continue to assume, as some jurisdictions have done in the past, that if you just let the market forces take their toll, things will improve because of competitive pressure. We're just at a position now that some intervention is necessary. And I think the key in a global perspective is just to prevent a race to the bottom, to make sure that all agencies are aligned and we don't see agencies that try to provide for possibly a bit of a lax regime because they think that they can attract investments and so forth. So this is just kind of a thought on the global dimension. In terms of implicit collusion, so from a competition law perspective, we don't ask for intent. We can use intent as part of the proof, but we don't ask for intent. But really, the question on implicit collusion absolutely hits the crucial element here. If I go back to hub and spoke, if I'm the first one using a provider, of course I have no intent. Bill hears about it because I talked about it in an interview. He decides to use for his company the same provider. Does he now have some sort of illicit intent, or is it too far? Is me interviewing actually a signaling? Or if you think about tacit collusion, what is the dividing line between tacit collusion, where it's basically just us reacting rationally to the market, and concerted practice? If I mention to someone that I'm using a certain provider to design my algorithm, if I mention that I create friction between my customers and other options, is that enough to actually bring us in line within the scope of collusion or not? And last comment on that, the important thing to appreciate is that on collusion, we can probably intervene if we can identify hub and spoke, resale price maintenance. When it comes to tacit collusion that we did not discuss, even if you see that there was an intent to facilitate tacit collusion, under current laws, tacit collusion, conscious parallelism, flies below the radar screen. There is no illegality there. And this is something which is open for debate. I'll stop with that. Thank you.
Thank you very much, Ariel. So we've got another question from Andrew Thompson, and he's asking what kind of regulatory responses are most effective for tackling harms from personalization. So we've obviously covered auditing and how you might use actually internal audits or third-party audits. I'm really interested to understand whether people have got any additional thoughts on this. So, Christo, I see that you'd like to take this question first.
Yeah, I can take part of this. On the question of whether we need to regulate or constrain the kinds of data that people use. I'm not opposed to this, but we have to be very cognizant of the limitations. We say, well, you can't use race data in your model, but you're still using zip code, which is a strong proxy. And we say, well, you can't use zip code, but you're still using Facebook likes, which are a strong predictor for things like interest in different cultures and racial affiliation. So trying to get to a specific outcome, neutrality or parity along a specific line by slicing and dicing the data thinner and thinner is really a kind of a fool's errand, especially when we're talking about very rich data and very complex models like neural networks. Instead, I think we have to go back to something that Kathy mentioned, which is really just looking at outputs, right? What is the outcome of the system, regardless of kind of how you got there? And if the outcome has some kind of problem, some kind of normative issue or market corrupting issue, that's the harm, that's the problem. And then we have to say, well, you have to do something about that. And it's not necessarily for the regulator to say how you get to it, right? You still have to get to that objective anyway.
That's great. Thank you, Christo. So Ariel, we'll move over to you next on the same question, and then over to Bill.
Yes, so just to add to that, from a market perspective, what you could do is just have better information and transparency to empower consumers to be mindful of how exactly the landscape is operated. So it is about education of customers and about giving them options. The problem is, how do you exactly do that? Do you just state, for example, that the price you got was personalized? Is that enough? And if you do that, are you actually distorting the market or not? And this is where it becomes very challenging, because in a normal market, if you go to kind of, let's say, a fish market, no one tells you if the price is personalized based on how you appear or how you're dressed. So the question is, should we have a different responsibility when you go online, and how do we play with that? So I think more information is the answer when we think about the market mechanism, but it has to be carefully constructed in a way that does not actually distort the market and create another effect.
Yeah, Ariel, Bill.
I think this is an area where the promising research that has come from for regulators, that's an important frontier of research, is how do you provide information in a way that's informative to consumers so that they understand what's going on? And then how do you give them a menu that actually matters to them in helping them guide their choices? This effort to formulate policies is an important effort to inform the basis of policymaking. Just what do people actually do?
That's great, Bill. Thank you very much. So, Kathy, I'm be interested in your thoughts on this question, or in fact, any other closing thoughts from you.
Well, I mean, just very generally speaking, I'm extremely heartened to be part of this conversation and to hear that you guys are well advanced and you're thinking about how to form this team. And I think there's going to be a lot of work and a lot of education, ongoing education. I think of it kind of like there's an arms race going on that we didn't even know we were in. And the regulators stepping up to educate themselves and think through these kinds of questions and the kind of basic auditing frameworks that they need to set up, and then with help do slightly more complicated things, maybe with third party. I'm seeing it as, just the beginning of a very important, like if not urgent, and much larger project. And I'm really glad to see you guys getting it started.
Brilliant. Thank you, Kathy. Thank you very much. And thank you to everyone. So just a few of the things that stuck with me. So I've certainly heard from many economists. I'm primarily an economist, talking about not finding personalized pricing. And I've certainly heard from some economists that there's some real skepticism of how much it exists. So it was really interesting to me to hear from Christo's perspective that he's actually fairly skeptical it exists. And it's not just from his work, but actually from talking to firms directly. But it's very interesting also to get his thoughts on nudging as well. So I found that very useful. From Ariel, I took away both, yes, let's focus on hub and spoke, but also the Truman Show idea, which I think is going to stick with me for a while. Bill, he talked about the length of time it's going to take for the US cases, but they're going to be really fascinating, but it's going to be a while. So that really stuck with me too. Kathy was focusing on really us trying to think really broadly how collusion may happen, and it could potentially be in the data as well as other forms. And she also talked about the nature of black box algorithms, how we have to really focus on, ultimately, it's the outputs and outcomes that come from that. Christo next talked about that explainable AI certainly has its role and can help us kind of understand algorithms, but but there's some limitation to that. He talked about mandated third-party auditing and actually the internal auditing idea, which is very new for me. And very importantly, Christo focused on the role for making sure that him and others are legally able to make. So again, for those in the CMA or for other parts of the government, I hope we all heard his clarion call. Then we had thoughts from Bill about how we would be able to work together internationally. And he in particular mentioned the data unit that we've set up at the CMA and the importance of other agencies setting that up as well. And so I'd say we're incredibly keen to work with them.